Are you Mr. Cruz? Counsel, you received all discovery. Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Cruz, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
No, Your Honor, we'll be waiving the repeat offender enhancement.
All right, did you review the admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine, affirmative finding of deadly weapon, affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be your plea? Defense, is that the plea? State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There'll be 100 hours of community service restitution, anger management, a TAP evaluation, and an MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? All right. State, any evidence?
Yes, Your Honor, this time state offers and evidence with one, all attachment.
No objection. All right, and state, have you spoken with the complainant?
Yes, we have, Your Honor.
All right, thank you. You may be excused.
Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Again, and did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and
Right here, the court actually finds him guilty but then hits pause by granting deferred adjudication. Translation: the defendant is technically guilty, but if they follow strict probation rules, they can avoid a formal conviction. High reward, but also high risk one slip-up, and it's back to prison time.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? All right, what's going on with your life? Why would you attack your brother? Well, that's like not a normal reaction. You get mad and you stab your sibling. So what is going on in your relationship with him? There's more going on than just this night.
I think part of it, one way it was just, infidelity between, baby mother, thing.
No, this is you being upset with him because you wanted to use his phone and you stabbed him with a screwdriver.
Yeah, but but that, it's,
What's stuff on the phone? Are you saying that he was cheating with your significant other?
not necessarily, like, just talking, but just, Google, the messages and stuff like that, it's all,
Well, it takes two.
Yeah.
Right? And of course, both, then you're in a situation where your brother owes you loyalty and the person you're with owes you loyalty, but you don't get into an altercation with them because you end up with a felony. You either accept it or speak to them calmly about it, or either you cry to whoever will listen and let it go and just say, you know what, I'm done with you all. Or, hey, brother, this is inappropriate for you to be speaking to the person I'm in a relationship with. That's how you solve that. Now you have this. So what are all the tattoos on? What are they about? I mean, what's the significance?
tattoos that I have, 17.
Okay, why are you getting tattoos? What do they say? No, I mean, you got a name over here, a name in the center of your chest. Who are these people that you tattooed on your body?
One of them is, it, the other one, the one on my chest is, it's the same, that comes with, it's not a name.
Mhm.
The other one is, it is bigger.
Okay. Okay. All right, this is what the court is going to do. There's a $1,500 fine that will be probated. 6 years deferred adjudication. I'm gonna want a gang evaluation done. There's an affirmative finding of family violence, an affirmative finding of deadly weapon. There's to be no contact with Samuel Cruz. If later you're doing well, I'll consider lifting that. 100 hours of community service restitution. How far did you go in school? All right. If you obtain your GED or some type of trade school, the court will find that the 100 hours of community service restitution is satisfied. There's intoxication involved in this, but based upon what he said was on the phone, there is also some anger issues going on too. I'm not going to ask for the MRT, but I am going to ask for anger management. And there's to be a TAP evaluation, follow recommendations. No. Have you used any type of drugs in the past? And what would that be?
Okay, this is wild. The entire stabbing incident came down to an argument over a phone and possibly infidelity. Let's be real. Was this about loyalty, jealousy, or just straight up rage? Drop your thoughts in the comments. What do you think really set him off?
All right. Do you have any violent criminal history other than what you're here for today? All right, and just a deadly conduct? I'm sorry.
That's not correct, I can do. Left with you lights like that.
Well, the reason why I'm asking, because maybe he needs to be in felony drug court, but they do it on a case by case basis.
It's not really good, it is like.
Yeah, the anger management.
All right, so we're gonna do anger management, TAP evaluation, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors, and no residing with minors. And I'll go ahead, I'll do a referral to felony drug court, and that will be in custody. Felony drug court will see you probably by next week, and it'll be done by Wednesday. A TAP evaluation in custody would take 2 to 3 weeks. So that's why I'm doing the TAP evaluation out of custody. But if you miss any of these appointments, what will end up happening is a warrant's going to be issued for your arrest because it's a violation of your probation. Do you understand? And there's going to be field visits 1 time per month until further notice. Is there anything else you need from the court? All right.
Meet with probation, speak to.
Yes.
Along with the court about.
Yes, and we'll have him brought over.
And I'll be here.
All right, thank you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, thank you. Yes, custody. Bashan, I'll send you the email with everything I wrote down. All right.
That's it there for you too, Michelle.
Yes, he does, but see if the next door is available. Okay. All right, and my understanding is that the jury is ready. So who is your next witness?
The state's gonna arrest you on it.
Okay.
We are gonna ask for directed verdict. on my-
Okay. All right, so what I'll do is I'll have you all rest in front of the jury. And then I'll have them just wait in the hallway and I can hear your arguments. Okay,
And then Judge, I had a brief moment to look at the charge as well.
yes,
Just the inclusion of the word young was the only thing I found.
It's
For-
there a lot, yeah.
okay, just give me 1 moment. Let me put this in.
Here's a twist the judge offers to reduce community service hours if the defendant gets a GED or trade school certification. It's basically the court saying, better yourself, and we'll go easier on you, smart incentive. But do you think it actually works?
Sure, you can come this way. You can talk to him next door, man. Okay. Well, I think. We're in trial itself, there, so I need to move in. You can talk to him next door if we need to. Okay, I'll go next door, thank you.
Sean, did you see that real quick? You're welcome.
And I'm sending it, emailing it to you now. Just give me 1 second. It'll be 2 more minutes.
Huh.
It's in here way more.
Just the ones that I saw, but she can just control that.
Wow, sometimes younger.
Definitely says that. You wouldn't say he's young very.
Younger isn't here a lot, yeah, child younger than it was 17.
Oh, that's true. But she can just.
Right.
No, you're definitely, you're right about that.
Jack, do you have a copy of my back?
I do not have a clean copy of the, actually, yeah, I do, in the file.
Yes, ma'am. I lost my.
I took your copy.
You did take it.
But it's marked. A clean copy. That's helpful. The only clean copy I have.
All right, Bashan, I just sent it.
Okay.
Are we ready for the end?
Yes, thank you. All right, thank you. And Rashana, on Mr. Cruz, from reading the police report and everything and what he said to me, he has a heavy alcohol issue. So when they're testing him, make sure it's for alcohol. All right, thanks. All right, so deputies, my understanding from the state is they're not gonna call any more witnesses, they're gonna rest. So once they rest, we'll have the jury step up for a little bit, because then they're gonna make some arguments, and then we'll bring the jury back in. Because my understanding is that the defense may have witnesses they're gonna call. But we won't be doing closing arguments or any of that today. They'll probably be on Monday.
Do you want to?
Yes, please. All right, we're back on the record in 2024 CR 006930. State versus Alexander Rodriguez. Are both parties ready to proceed, state,
Yes, Your Honor.
defense?
Yes, ma'am.
And the court will note for the record that Mr. Rodriguez is present.
And now we've hit the bombshell moment. The defense asks for a directed verdict. That's basically them saying, Judge, the evidence is so weak. Don't even let the jury decide, just throw it out. These motions rarely succeed, but they can totally change the game if granted.
Seated. All right, defense, you may proceed.
Yes, Your Honor, we're moving for a directed verdict. As to count one specifically, there was testimony that there was no penetration of the anus of Emily Rodriguez, so we are asking for directed verdict as to count one. And then as to count two and count three, the credibility of Emily Rodriguez has substantially been challenged, and therefore we are asking that the court find directed verdict on count two and three due to the lack of evidence of any corroborating evidence for the alleged victim. And we are asking, there's not a scintilla of evidence with regard to the penetration of the anus or the credibility of Emily Rodriguez.
All right, so with regards to count one, if the court were to rule that there's a direct verdict as to subsection one under count one, then numbers two and numbers three would still stand. All right, so let's address count one, subsection one under that state.
Your Honor, the complainant did testify that, in the beginning, she said he put his thing in my butt, and she did testify to that on the stand. Those were her words. We had to go and do further about thing and butt. Even if there was inconsistency, she still testified to that on record. And in her forensic interview, the outcry witness, where we had the proper hearing, testified to her explicitly mentioning that as well. Juror can make a reasonable inference with the yelping and the jumping and the pain with respect to the penetration of the anus. So with respect to a scintilla and multiple witnesses mentioning it, again, with respect to argument later on, of course, but with respect to a directed, the state does not believe that that would be appropriate given the multiple areas of testimony that speak to that element or sub-element, if you will, of count one specifically.
But with regards to testimony from the outcry witness, that's not hearsay because it's not being offered for the truth of the matter asserted. Isn't that correct?
Yes, Judge.
So whether or not she told the outcry witness that that there was penetration, it's not being offered for the truth of the matter asserted. So the court has to look at whether or not the witness testified that there was penetration of the anus. I'll have the court reporter look for that in the record. So with regards to your request for a directed verdict for number one, subsection one, I'll have the court reporter look in the record because I think there was some testimony towards the end where she may have said that, but I want to be certain before I make a ruling with regards to number one. Let's move on to count two. No, they've already mentioned
I
counts
guess
two.
Yeah, they went through the whole, yes. With respect to count two, Your Honor, again, there's very clear testimony that was given both by the forensic and by the complainant with respect to the touching of the breast. She had mentioned this multiple times, placed his hands there. And the grab was specifically a verb that was mentioned. So there's direct testimony related to both. Well, I guess just speaking to count two, there is that direct testimony from the complainant here in court.
All right, so with regards to count two, the court is not taking in consideration what was said by the outcry witness as to whether or not a directed verdict should be granted for count two. The court is going based upon testimony, other testimony that was received. So defense with regards to count two, your directed verdict will be denied. Let's move to count three.
Same thing, Your Honor. There was testimony with respect to the defendant placing his hand on her vagina. And that was testimony given by the complainant on the stand.
Okay. All right. Just give us a moment, and could you look for the penetration part?